Hello, and welcome to PubK's 2023 Government Contracts Annual Review. We're thrilled to have almost 4,000 registrants for this entire program. Over the next 4 afternoons, we'll present 9 additional sessions with over 30 presenters and almost 17 hours of content. We hope you'll be able to join us for most, if not all, of these sessions, but a separate registration is required for each session that you want to attend. My name is Alan Schwatkin. I'm the president of the PubK Group and a partner in the law firm Nichols Lute. I'll be your host, facilitator, and moderator for this year's annual review. The PubK Group publishes 4 newsletters: PubK Law, PubK Compliance, PubK Cyber, and our newest, launched in mid-2022, PubK M&A. Many of you are already subscribers to one or more of these publications, and we very much appreciate your support. Some of you joining this annual review are not yet subscribers, but I hope you'll consider becoming a subscriber. Information is at the website shown on the slide or is available for many of the contacts you have at the PubK Group. This conference would not have been possible without the strong support of our event sponsors, all of whom are listed on these next 2 slides. I encourage you to look at the skills and capabilities these firms have and reach out accordingly. Also new in 2022, PubK joined with Arnold & Porter to launch a periodic podcast called Bonafide Needs, covering emerging issues and interesting interviews. We'll continue that in 2023 as well and encourage you to access them through our website. But if you're interested in partnering with PubK on a podcast, we'd be pleased to discuss this opportunity with you at your convenience. In lieu of speaker gifts and in honor of our sponsors, PubK is making a contribution to the Capital Area Food Bank. With the food crisis facing our communities, including the military, and particularly here in the Washington, D.C. metropolitan area, I hope you'll consider making an individual or an organizational contribution. Since this entire program is being held virtually, all attendees will be in listen-only mode. Your video will remain disabled throughout the sessions. But we welcome your questions. Use the Q&A box at the bottom of your screen. However, with so many attendees, it will not be possible to answer all of the questions in real time. We are capturing your questions and will endeavor to answer as many as possible after the conclusion of the annual review. However, all presentation slides are available now for download for this panel, and all of the presentation slides along with the audio will be available for download for the entire program, probably within a week or so at the conclusion of the full annual review. We'll send an email when this information is available for download, how to access it, and for how long the material will be available. We're also applying for continuing legal education approval in Virginia, California, Texas, Florida, Colorado, and Kansas. While we cannot guarantee approval, we expect that acceptance within the next few weeks. Again, we'll notify all attendees when those approvals have been received. So if you're interested in obtaining CLE, please look for our poll question during the presentation. The state boards require us to verify your participation during the event. We will keep track of responses to verify that you viewed the panel. If you don't wish to obtain CLE credit, you can disregard the poll. Now, I'm thrilled to continue this 8th PubK annual review with our session 3 panel on labor and employment. Our distinguished panel members are Nicole Atala from Polaro Mazza, Howard Wolfrado from Abraham's Wolfrado. Joining us for the first time, Trina Fairley Barlow of Crowell and Mooring, and last but certainly not least, Mike Schreier from Hush Black Will. Nicole, over to you.
Thank you so much, and thanks to PubK for having us today. We have a lot of content to cover today. I'm sure my fellow panelists would agree that we are going to do our best to cover the hot topics in labor and employment for government contractors in the next hour and 50 minutes or so. We're going to kick it off with some OFCCP trends and new certification requirements. Next slide, please. The OFCCP had a busy year in 2022. We talked about this at our last annual review, what was kind of coming down the pike and what we saw coming down the pike in 2022. Some of that came to fruition, and I think everyone got their gifts and probably a little bit more than they asked for Christmas. We started off recently, we had FOIA FOIA request go to the OFCCP requesting component 2 data from government contractors that had, not just government contractors, but anyone that had multi-establishment filings. This FOIA request came from an organization that is well known for requesting information from government agencies. They use it for a variety of reasons. Some, folks unfortunately end up on a website somewhere with their data out there in the universe. So this quickly became a concern for our clients in the government contracting community. And the requirement was that if you did not want your EEO1 data released, you had to file an objection with the OFCCP. The OFCCP had a few challenges in managing all of the objections, but they were responsive. They extended the deadline a couple of times. We'll be curious to see how the courts, because I'm sure this will be kind of running up the rank in courts as this question has in the past, to see how courts will handle the question of whether EEO1 data can be considered confidential under the FOIA exceptions. So we're watching that closely going into 2023 because it has broad implications for other FOIA requests from outside organizations that want to capture data for a variety of reasons. Another 2022 update was the predetermination notice proposed rule, which is kind of working its way through. What the takeaway is on the predetermination notice proposed rule is that the OFCCP is really trying to make it easier for the OFCCP to kind of rush investigations. There are no automatic extensions when you are getting record requests under OFCCP investigations. They've shortened the response timelines to 15 days. They're also making some changes with respect to compliance agreements that are working their way through OFCCP. I think this indicates a clear indication that the OFCCP wants to be more aggressive in its investigatory matters, and they want to pressure contractors to get their information in, and hopefully from the OFCCP standpoint, I think to reach some sort of agreement for compliance without a lot of back and forth. So this is, I think, an indication that OFCCP intends to be more aggressive with respect to its investigations towards the throughout 2022, I certainly saw this, and I expect to see that again in 2023. There's also the pay equity directive that kind of worked its way, I think, kind of summer, early fall of this year. What the pay equity directive really is getting at is this desire from OFCCP to have contractors do a pay equity analysis. The director at OFCCP has a long history of being interested in pay equity. And you're seeing that really come to fruition in the pay equity directive. It requires that contractors do a pay equity analysis to make sure that their pay practices are not discriminatory on the basis of not only gender, but race and ethnicity as well. It clarified that OFCCP can request a copy of that analysis. There is some question as to how broad that authority really is to get that information under, the OFCCP's general umbrella of authority. So we'll be watching this very closely in the coming year to see how broad those requests are, to see how many of them we're seeing. But the takeaway here is if you haven't looked at your pay equity practices as a government contractor, that's something you should really be putting on your reader board for early 2023. You don't want to be surprised by a request. You want to have at least conducted some sort of analysis. The other question was whether, to what extent that pay equity analysis really, how far does that have to go? How formalized does it have to be? And we really don't know the answer to that question yet. I expect it to vary based on the investigator and that's requesting that information. Next slide, please. One of the major, ticket items in 2022 was really affirmative action plans. So just as a refresher, if you're a government contractor, generally, over 50 employees, you should have an affirmative action plan. If you don't have an affirmative action plan, you might want to phone a friend pretty quickly. There were certain dates we talked about in the last annual update. The portal kind of opened on February 1st, 2022. By March 31st, 2022, contractors were supposed to certify that they were in compliance with AAP requirements. And by June 30th, you were really supposed to have filed that affirmative action plan. If you haven't done it, just get caught up, basically. And if you don't have an AAP, what we found is that, there are a number of organizations out there, in addition to legal counsel, that can help you get your house in order with respect to your AAP. Probably the number one complaint that I hear in my office is, it just really wasn't on our reader board, and we don't have all the data that we need in order to complete an AAP. Don't let that stop you from getting it done. There's a way that we can, together with, resource providers kind of account for that and at least get something in place so you're not kind of caught, unawares without that AAP in hand. So there's a lot kind of happening. What we don't know yet is really what they're going to do with all of that data. So how are they going to use that data and investigations going forward? It's certainly put a spotlight back on AAP compliance. I think a lot of contractors, this is not something that is immediately on their reader board and really needs to be. It's one of those, it's not an issue unless it's an issue, and then it becomes a big issue really quickly. Next slide, please. Moving on from the OFCCP, we wanted to touch a little bit on the NLRB, collective bargaining agreements, and contractors. Next slide, please. So as you can imagine, the Biden administration has been very aggressive when it comes to initiatives at the NLRB. The board is, of course, not as conservative as it used to be under the Trump administration. And we've really started to see that come to fruition in 2022. It would be impractical to cover all of the updates at the NLRB this year. So I tried to focus on various cases and initiatives coming out of the NLRB that our clients are particularly concerned about. One of the most recent cases was Thrive, and that came out just recently in December of 2022. And what it does is it makes employers responsible for direct and foreseeable damages relating to an unfair labor practice. So if you're unfamiliar with how this works, whether or not you have a unionized workforce, an employee that is aggrieved and feels like there's been a violation of the National Labor Relations Act, either because they've been disciplined or terminated as a result of protected concerted activity, or they feel like, you have done something inappropriate as they try to unionize, they can file an unfair labor practice at the National Labor Relations Board. In the past, we were, more focused on whether or not there were direct damages as a result of a termination or discipline. That might result in some monetary award. It might result in something as simple as a notice posting if you take a wrong term, but there are no monetary damages. Thrive changes that calculation to a significant degree in that it makes an employer responsible for direct and foreseeable damages. Think attorney's fees, which we really didn't have to focus on too much before. A lot of, consequential damages. It really broadens the scope of the calculation of damages that we could see in these types of cases. The NLRB has already been very aggressive with respect to damages and settlements. We expect this to empower them at the investigation stage before these cases go to the to an administrative law judge. I do expect that this will be challenged and that it will be working its way through the courts, because I think there is a question as to how broad this case really was and whether this is, appropriate under the regulations and statute. But until that point in time, I fully expect that those investigators and general counsel at the NLRB will use this to their advantage. An initiative that got a lot of attention this year was the joint employer proposed rule. A lot of folks were very concerned about impact here. Now, what this proposed rule that was issued on September 6th, 2022 said was that those that share or co-determine those matters governing employees' essential terms and conditions of employment, such as wages, benefits, and other compensation, can be held to be, and I truncated there, can be held to be joint employers. The immediate reaction for some of my clients was, oh my, this changes the landscape. What it really is a continuation of a rule that was issued during the Trump administration that interpreted current case law the way that the Trump administration and the Trump board really viewed that case law. This is a different interpretation based on the current board and the current general counsel's view. So it's really, it's more of the way I describe it to clients is it's the way that this general counsel is going to interpret joint employer cases. It's a way to tell employers in advance the way that it could go for them should they challenge joint employer issues in cases before the board. It doesn't change that case law, right? It really gives you an eye into how this will be viewed. And those of us that counsel clients in this area frequently would have probably told clients that this is what they were going to face with the general counsel and with the board in any case, but it certainly makes employers nervous, and we'll see what they do in the rulemaking process. It wasn't really until the Trump administration that we saw this type of rulemaking at least in recent history at the NLRB. So this is kind of something that we're starting to see how they will use rulemaking to shape how they handle cases at the board going forward. One of the only anecdotal things that I've really run into is staffing contracts. On government contracts, you have positions that are really staffing positions. And there have been some prime contractors that have taken the position that they really shouldn't, do this anymore. They should limit it, limited duration staffing. I always tell clients that those factors are always there, and you should always be looking at them when you're looking at joint employer issues, whether it's an NLRB issue, a Department of Labor issue, whatever it is. You should really be looking critically at those issues in any case. Not any one factor is determinative, right? It's still a balancing. And on balance, we want to be kind of away from joint employer or use our contractual instruments to protect us as much as possible. We've also seen the NLRB be very aggressive with respect to information requests. We've had a number of cases go to the board this year and before at the investigation stage with general counsel, where they have, the board has always interpreted investigation requests very broadly. Recently, it has extended, at least in our experience, to information that the contractor doesn't even have in their possession. Things like prime contracts, prime contractor information, publicly available information that the general counsel is taking the position that you could get. So just be aware that if you're getting information requests from a union, while that standard has always been a very broad standard, we've seen a more aggressive stance on information requests in the last year. There's also been a very deliberate effort to increase the scope of protected concerted activity. In the case Excel Protective Services, it was issued in September 8th, 2022. An employee was essentially terminated at the Navy's request for complaining about an employer's or contractor's training initiative. That employee complained up the ranks at the Navy. Ultimately, the Navy determined that there was no merit to this contractor employee's claim, and at the same time requested the employee's removal from the contract. Of course, the contractor removed at the Navy's request, and the board found against the contractor, finding that the contractor had engaged in protected concerted activity and could not be removed, that it was essentially a retaliatory removal, even though the Navy had requested the removal. I am sure you all have been vexed once or twice by a government request for removal. They are complicated situations, whether it's an NLRB issue or an EEOC issue, but this case gives us another reason to be concerned about what will be considered a protected concerted activity. We also have a case pending before the board right now on appeal from an ALJ decision that in that particular case, the NLRB, the general counsel, is taking the position that protected concerted activity extends to complaints made about government directives. In that case, it was a government directive on scheduling. The The employee complained and complained and complained. Finally, the government asked for her removal. Again, another removal case. And in that particular case, the board is taking the position and would like, or the general counsel is taking the position that protected concerted activity extends not to just the employer's terms and conditions of employment, but to a third party's terms and conditions of employment. So that we are watching that case very closely right now because it would overturn board law and greatly expand what is protected concerted activity. Next slide, please. I just wanted to mention a couple of things about collective bargaining agreements because we have seen some significant issues with respect to bridge agreements. So I say to bridge or not bridge. So if you're unfamiliar with what a bridge agreement is, usually arises in an SCA context when there is a collective bargaining agreement that's incorporated into a contract. It goes out to bid with that collective bargaining agreement in there. And then the next contractor picks up a majority of that workforce and the union comes to you and says, I want you to just sign on to that old CBA that you weren't a party to because the last contractor was a party to it. The problem is that we've seen a number of cases where the pension that was written into those agreements is not in a particularly healthy state. There is some funding issues. And of course, the pension agreement isn't written into those bridge agreements, right? So the contractor thinks they're supposed to be paying, $3 an hour, $6 an hour. And along comes the pension fund and says, no, we're in a rehabilitative state and you have to pay this extra contribution that was never written into the CBA, but is a requirement of the pension agreement that's referenced in that CBA. This is just kind of my overall, warning shot that you should be asking all of those questions prior to signing on to a bridge. I am not a particularly big fan of bridge agreements, but if you decide that there's a necessity, you should be asking all of the questions you can about pension considerations. You should be looking at the timing of those collective bargaining agreements and any increases to make sure that you can qualify for price adjustments. And you should be looking at the impact of any government requirements that could impact your collective bargaining decisions. Remember, your contract with the government is completely separate from your contract with the union. And unless you connect the two somehow with respect to, if the government says I have to terminate someone, then I have to terminate someone, the union can hold you accountable for a not for just cause termination. So just be careful. We have a lot of issues with this year over year, and it seems to have come up a lot for us in 2022. Next slide, please. All right. Last topic on my list is really the COVID health and safety update. I know on everybody's list right now. Next slide, please. So what we saw in 2022 is the Biden administration really backing off enforcement of Executive Order 14402. They said, look, we're not going to enforce it for now. It's still working its way through the courts. So in August, we saw that the 11th Circuit narrowed the scope of the nationwide injunction so that it only applied to a certain number of states. And then in October 2022, we saw the Safer Workforce Task Force come out and say, yeah, we're backing off the enforcement of this, but we're going to give contractors some additional guidance on how they should be handling COVID in the workplace and on federal sites. Keep in mind that the guidance that's out there online is updated. They might not be enforcing the vaccination mandate, but they are still watching transmission rates and health and safety on federal work sites. On December 19th, so just a few weeks back, the Fifth Circuit blocked again enforcement. And what was really interesting about this decision is it really addressed the presidential power to promulgate a directive like this. And so it goes further than just the vaccination mandate. It's really talking about the authority that the president has and makes some significant, some interesting analogies along the way. It's a really interesting decision to read if you are interested in presidential power and the Procurement Act. But what this case says is, this is not like other things, and he really could have done this different ways. And we really think that this was beyond presidential authority and you can't do it. And so we'll see kind of where it goes from here. But I think more so than the vaccination mandate itself is the idea of really limiting presidential power under this tool of executive orders, which for a number of years has been used to push initiatives of the president that really are not going to get through Congress because of, Congress is effective. Next slide, please. I also wanted to just mention that as transmission rates rise in states, we are seeing that Safer Workforce Task Force guidance kind of start becoming relevant again. So, for example, West Virginia now is listed high, which requires the agencies like, for example, the ATF now is saying in West Virginia that employers have to or anyone on site has to be tested before they come on site and test negative before they come on site, and everyone has to wear a mask. What this essentially means for government contractors in high transmission areas that, you might have to get back in the business of reasonable accommodations. Can someone work from home? Is an objection to wearing a mask? Is there a medical reason, a religious reason? So we're kind of back in that zone of, requesting exceptions from a testing requirement or a masking requirement. The transmission rates are updated every Thursday. So as we go into, cold and flu season, I expect we'll see other areas that work their way into high transmission areas, and we'll be watching agents to see what agencies do with that very closely. If you're curious, what those requirements will be at low, medium, and high, there is extensive guidance if you would like to read through that on the Safer Workforce Task Force website. And with that, I will hand it over to Howard. Howard.
There, unmuted myself. Good afternoon, everyone. My name is Howard Wolf-Rada from the law firm of Abrahams Wolf-Rada. I appreciate the opportunity to speak with you on topics that are related to the wage and hour laws and the executive orders that exist with respect to federal contractor minimum wage requirements. You should consider this both a refresher, but also an update and a focus on some of the compliance potholes, if you will, that you can find yourself hitting in managing the various rates that could be applicable to your workforce. Also, at the end, I'll touch on briefly the newly issued independent contractor rule that is under consideration by the Department of Labor, and a brief mention about DOL enforcement practices. But first, let me lead off with the executive order requirement. As many of you may remember, President Biden issued an order increasing the minimum wage payable to federal contractor employees back in 2021. It increased the rate first set in an executive order issued by President Obama. When the Obama executive order was issued, it provided for a minimum wage rate that, as of the time that President Biden was increasing it, was $10.95 an hour and $7.65 for tipped employees. The new rate became, as of January 1, 2022, $15 an hour and $10.50 for tipped employees. And it provided for annual rate increases indexed to the Urban Wage Earner Consumer Price Index. Next slide, please. As of January 1, 2023, the new rates under the executive orders, and you have a new executive order rate and an old executive order rate. Under the new one, the new rate is $16.20 an hour and $13.75 for tipped employees. If you're doing your math, you may notice that the tipped employee rate went up at a much higher percentage than the overall rate. This is because the Biden executive order intentionally decided to bring tipped employee minimum wage equal to the minimum wage payable to all employees, and that's matching is going to happen as of January 1, 2024. So next year, whatever increase happens to the overall rate, the tipped employee rate will match it equally, which means it could be, I'm guessing, probably in the $4 or $5 range increase at the end of the year. The old executive order rate, however, does not have that kind of transition for tipped employees, and therefore it will just track the price index wage rates. The new rate is $12.15 for overall employees and $8.50 for tipped employees. Next slide, please. So now that we have some new rates, and given the interaction of those rates with rates required under other laws, such as the Service Contract Act, as well as state and local minimum wage rates, compliance is getting more complicated. So I'm going to touch on a few aspects of compliance and figuring out what your responsibilities are. And these include questions such as, is your contract covered? If so, by the contractor minimum wage orders. You then need to ask which order. You need to figure out who's doing what activity, because that has implications about what rates they'll be paid. Then you turn to what rates will be paid. And that can be confusing because you've got the contractor minimum wage rate, you've got Service Contract Act rates, and you have state and local rates. And at the end, when wage rates increase, are you entitled to a price adjustment for, particularly for fixed price contractors, in order to cope with the increasing minimum wage rates, whether they come from the executive orders or the service contract or Davis-Bacon. Next slide, please. Okay, so is your contract covered? Well, covered contracts include contracts with the federal government for services that are governed by the SCA, construction if they're governed by Davis-Bacon, concessions contracts, even if those are excluded by the SCA coverage. And then finally, category contracts in connection with federal property or land and that are related to offering services for federal employees. I will just defer to that description without going any further. If we could go to the next slide, please. So bear in mind, there's 4 categories of contracts, but another aspect of the definition is what is a contract or contract-like instrument? In this case, naturally, if you've got a prime contract that was issued under traditional FAR procedures, that's covered. But subcontracts are also covered. There's a flow down requirement. But then you've got task orders, cooperative agreements, doghouse construction agreements, henhouse support services contracts, and outhouse maintenance and cleaning contracts that come from, that's not literally in the definition, obviously, but there's a long list of types of contract instruments that are there. All right. All these different kinds of agreements that smell like a contract are covered, but still, if you go back to the previous slide, please. These are the categories of covered contracts. So if you have a federal grant, then it's not going to be subject to these contracts, probably. All right. So track the categories of covered contracts, but then virtually any piece of paper that constitutes an agreement will probably be covered. All right, if we could go forward 2 slides. Okay, I focus on the term contract. Why? Because the obligation to pay the federal contractor minimum wage is tied to what's in your contract. All right, so there is a clause numbered 52.222-55, minimum wages for contract workers under Executive Order 14026. All right, that was promulgated in January 2022. But if you're under the old executive order, you have a different clause that bears the same number. 52.222-55, minimum wages for contractor workers under executive order, here's the difference, 13658. It was dated November 2020 or earlier. If you've got that clause, your minimum wage rates are under the old order. If you've got the first clause, your wage rates are under the new minimum wage order. Now, if your contracting officer should have updated the clause, that doesn't matter. What's in your clause is what governs, what's in your contract governs what requirement you are supposed to follow. If they haven't done it properly, there is a distinct possibility that the Department of Labor, if there's a complaint, could come knocking at your door, and then you'll have to work with your contracting officer and the contracting agency to figure out how the back wages will get paid if they're needed to be paid, as well as to figure out how you'll be made whole for the contracting officer's error. That's a topic for a whole nother presentation. As I said, the contracting officer has the possibility of screwing up. They're supposed to impose the new executive order on the issuance of new contracts, exercises of options, and new orders under GSA scheduled contracts. So if you have a long-standing GSA contract and you haven't had any orders for a while, they're supposed to issue the new clause at that time. Next slide, please. The wage order, the executive orders apply to employees who work on or in connection with the particular contract that's covered. Working on a contract is pretty easy to figure out. It's if they're doing things that are in the scope of work. So if you have a janitorial services contract and you've got janitors working for you, those janitors will be covered by the contractor minimum wage executive order. But what I have found in, particularly in the last few years, both under these orders and the sick leave executive order, that employers get thrown off by the in connection with thing because they think, this stuff covers Service Contract Act employees. It actually covers a broader universe. In connection with means people who perform activities that are necessary to the performance of the contract, even though they may not be actually working on the contract. This includes, say, for example, a billing clerk who sends out the invoices for your contract to the government. Those would be in connection with that federal contract when they are doing that work. If you have people hiring employees to work on that contract, they will be covered when they're doing their HR function for that. In the construction context, if there are off-site employees who fabricate materials to go to the site for your construction workers to put into place, they could be covered. And this creates some tracking challenges because sometimes people might be working in connection with the contract and other times they might not. If they're spending less than 20% of their time working in connection with the contract, you might be excused from paying the federal contractor minimum wage, but instead be required to pay in accordance with other minimum wage requirements. But that's only if you carefully track whether or not they're working 20% of their time or less than 20% of their time in connection with the federal contract. Again, bottom line, you need to make sure you have good records about what work your people are doing, whether they're working on or in connection with the federal contract. Next slide, please. All right, I mentioned the issue of which rate. As I said, you've got the old executive order rate, you've got the new executive order rate. You also have, if you've got a Davis-Bacon covered contract, the Davis-Bacon wage determination rates. For services contracts, you'll have an SCA wage determination, but then you also might have a state or local minimum wage. You need to look at all of these different potential rates and figure out what rate covers your various employees. And that can be a complicated task. Next slide, please. For example, this is a couple of screenshots of a Davis-Bacon wage determination. I've circled in red this note that's at the top of the wage determination, which says, by the way, some of your employees may be covered by these executive orders. And then I circled in green some of the wage rates that are payable for particular classifications. You'll see there 2 asterisks after some of the wage rates. At the bottom of the wage determination, below the listing of the rates, you'll see this double asterisk footnote. Workers in this classification may be entitled to a higher wage. See the note at the top. So, you follow the various notes. Bottom line is, if you've got the executive order clause in your contract, that laborer who is a flagger, who is supposed to be paid $8.73 under that wage determination, you're going to have to pay them $16.20, right? And that's the way that the executive order requirement, it trumps the wage determination. Next slide, please. This is an SCA wage determination. Again, a couple of screenshots from the various pieces of it. Again, the note at the top, the note at the bottom. And then here, I circled in green just a certain excerpt of classifications. And you could see that the majority of that section of wage rates are below the contractor minimum wage rate, particularly under the Biden executive order. So there again, in those classifications, if you're abiding by the SCA wage determination and just aren't tuned in to the contractor minimum wage rate, you're not in compliance because you're missing those rates that are not covered. DOL handedly added those asterisks to make sure you're on notice about that. Next slide, please. But then if you're in a locality that has an even higher minimum wage rate, then you've got to abide by that rate. So in DC, it's currently $16.50 an hour. That's just above the current Biden executive order rate. It'll become $17 in July. San Francisco, the rate right now is $16.99. Denver, it's $17.29. In Seattle, it's $18.69. Okay, I've listed some cities there. There are state wage rates. I'm not aware of one right now that exceeds $15 an hour. So the state minimum wage rates won't cause a conflict between the executive order minimum wage rate. But you can see that you not only have to look at your contractor minimum wage rate, your wage determination rate, the state rate, but then also the local rate to figure out what minimum wage is payable to your employees. If you're a company that has multiple sites around the country, you can see where I'm getting at. There is a compliance web here that you can get caught in if you're not tracking each locality carefully for your workforce in the classifications of employment that your workers perform. Next slide, please. All right, now that you've figured out what rates you're supposed to pay, when those rates increase in some circumstances, you may be entitled to a price adjustment to account for the increase in minimum wages that are payable to your employees. Under the executive order contractor minimum wage provisions, if you look at FAR 52.222-55B3, you'll see that you can request an adjustment for increased labor costs, including subcontractor labor costs, as a result of an increase in the annual executive order minimum wage. That request can be increased. That request can be submitted only after January 1 of the year in which wage rate takes place. So then you have a situation where you might have off-cycle price adjustments because the SCA gives you a price adjustment for fixed price contracts on the occasion of the addition of new wage determinations. Those are usually added on the exercise of an option. If your contract has an option on October 1, your price adjustment request would be due by 30 days later. All right, coordinate that with any minimum wage rate increases. So if you could think back to that wage determination I showed you earlier, some of them will have price adjustments, price increases that are caused by the minimum wage executive order. Others will have price adjustment issues under the new under the SCA wage determination. I mean, the headaches that can cause are significant, and your compliance team needs to be tuned into not only what is covered, whether it's on a minimum wage order or it's a wage determination or it's a local rate. It's a tracking nightmare. And then, you know, in the category of sort of unfairness to contractors, you know, you're bidding for a contract in the services arena. You are prohibited from escalating the minimum wage, the wage rates that you're paying to SCA covered employees in exchange for the right to get a price adjustment whenever new wage determinations increase the wage rates. But if the state or local jurisdiction is requiring you to pay more than the rate that's in the SCA wage determination, you may then not get a price adjustment when those wage rates increase. And I think that poses an incredible conundrum for a number of federal contractors, because they're required to price their option years on a flat basis when it comes to wage rates. But if those wages are going up beyond those rates, there's no price relief. Now, there may be some other price relief available for inflation-related items, more broadly speaking, that are beyond the scope of this seminar. But basically, in those jurisdictions where the local rates are outstripping the federal rates, you may not have any price relief available to you. Next slide, please. Of course, the overall impact of these rate increases, as I said, more workers in more localities in more classifications are going to be affected. This means the compliance risk is escalating because the new contractor executive order rate may exceed more and more wage determination rates instead of a few like it used to be some years back. And the escalating local rates pose a problem. And of course, when the minimum wage rates increase for the entry-level folks, then that creates a situation of wage compression going upwards, and you have to consider the human resources impacts of all that, which then complicates your price adjustments even more. All right, next slide, please. So for compliance reasons, the rate change is significant, risk of error is high, and you have to have a much more disciplined approach to compliance than ever before. Now we'll transition to a brief talk on the proposed independent contractor rule. Next slide, please. This was issued on October 13th, 2022, so fairly recently. The comment period has closed, and now the final rule is under consideration. And the principal reason for this proposed rule is to reverse a rule that was issued in the waning days of the Trump administration, which changed the way the independent contractor rule operated with a much heavier focus on the issues of the degree of control an employer has over a worker and that worker's opportunity for profit and loss from their conduct of their work activity. In other words, the less control and the less and the greater, the less control of the worker and the greater that the worker had an opportunity for profit and loss, those two factors would be the driving force of that analysis, even though there were other factors to be considered. The Biden administration desired to return to the original pre-Trump approach to the totality of the circumstances in which all factors are sort of considered equally, and it's a much broader, not broader, but a much more comprehensive consideration of all the factors in relative equilibrium. And in its view that this would be more aligned with judicial interpretations of the independent contractor rule under the Fair Labor Standards Act. Next slide, please. So for those of you who are not totally tuned in onto what the totality of the circumstances means, there's 7 factors: the opportunity for profit or loss, depending on the worker's management skills. So if you're a good business person and you operate your work in a way where you can garner profit or loss based on that skill, that favors a finding of independent contract. If a worker has made significant investments in, say, for example, their tools of the trade or their marketing efforts or such things as that, that will favor a finding that the employee is an independent, that the worker is an independent contractor. But if the employer is providing all the equipment and such that the person just shows up and uses the employer's stuff, that's going to be more likely an employment relationship. You also need to consider the degree of impermanence of the relationship. If someone's always showing up to the work site or performing that particular task and to the exclusion of anything else, that suggests an employee relationship. Nature and degree of control. How heavily is the worker supervised by the company that has hired them? The extent to which the work is an integral part of the employer's business. In other words, is the work that's being performed by the worker a major part of what the company does, as opposed to merely providing a support service at the site, for example, janitorial service for a company that is not engaged in janitorial services. And then finally, the skill and initiative that the particular worker devotes to the work will favor an independent contractor status, whereas again, if the person's heavily supervised and they're not exercising high skills and initiatives, that may favor an employee relationship. And finally, there's sort of a catch-all: other factors, if they indicate whether the worker is in business for themselves and not dependent on the employer. And that's sort of the bottom line analysis, whether or not they're really functioning as a business as opposed to being an employee. Next slide, please. In conclusion of the overall my part of the presentation, I just want to recognize that the rule change on the independent contractor rule reflects a continuing Biden administration focus on employee rights and increased scrutiny on employer practices, which mirrors some of the things that that Nicole was touching on, that there's a higher level of scrutiny, an increased sense of urgency. In the case of FLSA settlements, there's an increased use of liquidated damages above and beyond the requirement to make back payments to employees. And there's also a greater likelihood of severe sanctions, particularly in the service contract area. If you have clients that are frequent flyers, if you will, who've committed a number of violations, it goes into their permanent record. DOL maintains a database of those past errors. If you have a record that's a little spotty, it's much more likely that you could face debarment for an SCA violation. And overall, there's just an ever-increasing complexity of wage and hour compliance for federal contractors. And I think your compliance teams have to be more and more attentive as time goes forward. And I turn it now over to Trina Barlow to talk about the non-displacement rules.
Great, thank you, Howard. In 2023, government contractors will be anxiously watching and anticipating the implementation of Executive Order 14055, which, as we just heard, is the non-displacement qualified workers under service contracts executive order. And this executive order was issued by the Biden administration back in November of 2021. And then the proposed rule was issued on July 15th, 2022. I'm not going to bury the lead here. The final rule is still pending. So we are expecting to see a final rule implementation probably any day here in 2023. But the executive order requires federal agencies to include a clause in contracts with government contractors stating that successor contractors and subcontractors who win bids for work covered by the Service Contract Act must offer employment to qualified, quote, service employees. We'll talk about who that is in a minute, who were employed under the predecessor contract. And this applies when a successor contractor will be performing the same or similar services as the predecessor contractor. What does this mean? This means that a successful successor contractor, try to say that a lot really fast, must give service employees a right of first refusal to retain their employment before the successful contractor can move on and hire other employees. Under the executive order, the purpose here is to create greater efficiency in government contracting and to create continuity of services, according to the executive order. And to those of you out there who are experienced government contractors, this will sound familiar to you. And this is very similar to Executive Order 13495, which was issued under the Obama administration. The executive order had the same name, but it was subsequently rescinded by the Trump administration. Two things to know about this executive order. Again, as I said, the rule is still pending. However, in the executive order itself, the agency was clear, the government was clear that they are actually encouraging contracting officers to begin utilizing the non-displacement rule even before they become final. So contractors should be looking at contracts and modifications just to make sure that there's no reference to this executive order. The other thing to know is once finalized, the Biden version of the non-displacement rule will have much broader coverage than the Obama era one. There'll be fewer exceptions and there will be greater administrative burden, as we'll talk about in a minute. If we can have the next slide, please. Thank you. So let's talk about the types of contracts that are covered. We mentioned it before. Contract under this executive order and the proposed rule is any contract-like instrument, or subcontract for services covered by the Service Contract Act. That's so what does that mean? That means that if you have a contract, for example, for construction, or you have a contract where you're providing supplies, it is not going to be covered by this non-displacement rule. But something else to know is that the definition of contract is broader here than it was under the prior version of this rule in the Obama administration. Under the prior rule, it was just contracts. But when it refers to contract-like instruments, that means you could have a purchase order that is covered by this non-displacement rule. It also means that under this new version of the rule, should it become finalized in its current form, that there will be a flow down requirement because the rule also applies to subcontractors. Now, let's talk about exclusions. While the rule is very broad, the proposed rule, in any event, there are some exclusions. While few, there are some. This rule will not apply to contracts under the simplified acquisition threshold, which in 2022 was $250,000, but of course that's variable. It also will not apply to employees who are hired to perform work on contracts that are both federal and non-federal contracts as part of a single job. So people who are performing a hybrid role. And then finally, the rule won't apply if there is an agency-imposed exception made. What does that mean? Under the Obama era rule, an agency could just determine that an exception was, quote, justified, and then decide that the non-displacement rule would not apply. Under the proposed rule, there will be, as I promised and previewed for you, more administrative burden, even for the contracting agency. It will have to assess on a case-by-case basis whether or not an exception is warranted. Then it will need to publish any exemptions made on a website, and then make periodic, at least quarterly, reports to the Office of Management and Budget. So it will be more difficult, at least in theory, to get exclusions, agency issued exclusions. Can we please have the next slide? Now let's turn to some of the particulars and logistics for complying with this proposed rule. One, as we suggested at the outset, good faith offers of employment, or as they're called, rights of first refusal, have to be made to all service employees as defined by the Service Contract Act. And what is a service employee? Those are individuals who are exempt under the Fair Labor Standards Act. So you're talking about individuals who are entitled to a minimum wage and to overtime for working in excess of 40 hours in a work week. But don't forget that the definition of service employee can be tricky under the Service Contract Act and can also include independent contractors. But who it does not apply to are those who are exempt under the Fair Labor Standards Act. So your executives, your professionals, those with managerial responsibilities as defined by that statute. So to avoid compliance missteps, it's really important for a number of reasons, but this is another one, to make sure that you are conducting a classification analysis to make sure your employees are not misclassified under the Fair Labor Standards Act. The second thing from a logistics standpoint that you need to understand under the proposed rule is that, as I suggested, you cannot make offers even to your own employees without first complying with the executive order. This is a change from the Obama era rule. Under the Obama era rule, it was okay for a successor contractor to not make an offer of employment to a predecessor's employees if their own employee had been employed for at least 3 months, and that their own employee would lose their job if the predecessor's employee were hired. There is no such exception under the new rule. Next, to comply, the successor contractor has to make an express offer of employment. And then give the predecessor employees no less than 10 business days to accept that offer. And when it says express offer, anyone knows what that might mean, but think written offer letters, something that you can produce and show if you need to ever prove that you took that step. May we please have the next slide? So we've talked about when you are required to make offers. We talked a little bit about when you're not, but let's dig into that a little bit more. We've already talked about the fact that you're not required to make this offer or right of first refusal to employees not covered by the SCA. And we've talked about what that means. That means not your exempt people, not your contracts, not your people working on contracts covered by Walsh-Healy or Davis-Bacon, but only those under the Service Contract Act. But there's something else new here that is worthy of note. The concept is not new because it existed under the old rule, but there's a twist now. Under this rule, successful successor contractors do not have to make an offer of employment to a predecessor's employee if that predecessor employee had quote, let me get it right, unsuitable performance. Under the old rule, however, what constituted unsuitable performance was really left to the discretion of the successor contractor. That is not the case under this proposed rule. There's a much more employee-friendly rule. Now the successor employer must demonstrate that there would have been just cause to discharge the predecessor employee if employed by the successor contractor or any other subcontractor. So what you would need now under this proposed rule is some evidence, for example, a proposed termination that had not concluded by the time the successor contractor won the contract. And you're all probably thinking now, how am I supposed to get records from a predecessor contractor about a proposed termination? And I agree with you. And so time will tell how that rule might function in real time. Maybe have the next slide, please. Great. So just briefly, still talking about logistics, the predecessor, in order to comply with this rule, there are responsibilities for the predecessor and for the successor. The predecessor shall rather not less than 10 days prior to the completion of the contract provide the contracting officer with a certified list of all prime and subcontract employees who were working on the contract within the last month. Obviously, that helps to facilitate those express offers that need to be made. And then the predecessor must also provide with that the SCA anniversary dates, which was the case under the prior rule as well. The anniversary dates are obviously really important for a number of things, including fringe benefits that have to be provided once you employ the new employee. And then the contracting officer then has the obligation to provide that list to the successor contractor. And note that an employee or their representatives may ask for this list. So that could be an attorney or a union, for example. And then let's talk about enforcement of this rule. There are significant penalties for non-compliance of this proposed rule, again, if it's implemented in its current form. Many of them were relevant and used under the prior non-displacement rule, but some are new. So it includes enforcement penalties may include being required to hire the affected employee and to pay back pay with compounded interest. There's also the possibility to have contract funds withheld, which we see a lot in the Service Contract Act context. But under this proposed rule, contract funds may also be withheld and provided to the employee as part of the back wages that might be owed. But you can also have contract funds withheld for failing to provide the required list as a predecessor to the contracting officers. So that has a little bit of teeth in it to make sure that that list goes to the successor contractor. And then, of course, as we see again with a lot of the Service Contract Act related rules, debarment for willful violations of up to 3 years is a potential enforcement penalty. Something that is new is under the proposed regulation. It includes an anti-retaliation provision. And so it authorizes the Department of Labor to order relief for affected employees. For example, if they complain about the failure to comply with this rule, and some of the relief might include reinstatement, promotion, and a payment of lost wages, again, with that compounded interest. So can we have the next slide, please? So speaking of the Service Contract Act, we wanted to give a brief update on enforcement activity related to the SCA. Howard sort of previewed some of it for us, but as we all know, the service, if we could have the next slide, as we all know, the Service Contract Act requires the payment of wages and fringe benefits contained in a wage determination or a collective bargaining agreement made applicable to a contract. And it also has myriad record-keeping obligations. What is, of course, scary about the SCA is that mandatory debarment potential that Howard spoke about. So let's talk about where the DOL is and what we're seeing as it relates to DOL enforcement of the SCA. One of the first things to note is that in February of 2022, the Department of Labor announced its plan to add up to 100 new investigators. And stated that it expected to ramp up that hiring late in 2022. So what does that mean? That means that if these 100 new investigators are on track to be hired or in getting into place as was previewed by the Department of Labor, it of course increases the likelihood of an investigation, which is a really good signal and sign for contractors who are covered by the SCA to think about getting their compliance house in order. The second update under the Service Contract Act that is noteworthy is that in 2022, the Department of Labor revised its field operations handbook, which is made available as guidance on its website, to remove the exemption for Job Corps centers. Initially, Job Corps centers for contractors and subcontractors performing work under Job Corps centers were exempt from the Service Contract Act under something called what we call the GovCon exemption. And this exemption, which is provided for in the regulations implementing the Service Contract Act, allows the government to enter into contracts and essentially delegate its responsibilities to contractors on a cost reimbursable basis. And that change means that the GovCon exemption no longer applies to contractors and subcontractors performing Job Corps work for Job Corps centers. And the practical effect is they too will need to ensure that they're paying the wages and fringe benefits that are made applicable by the Service Contract Act. So if you have one of those contracts, this would be a good time to check your contract language and any mods to ensure that you are compliant and in compliance if the Service Contract Act has been made applicable to your contract. And then I wanted to spend just a few minutes on some updates that were provided by the Government Accountability Office. Just as background, in 2020, the GAO issued a report identifying a number of areas for improvement related to the DOL's enforcement of the Service Contract Act. And then in 2022, the GAO provided an update report on how the recommendations that it made were are going at the DOL. Can we have the next slide? Thank you. So just to briefly review the 2020 findings by the GAO, because they're really they provide great information and some of them are startling, frankly, but the report notes that between 2014 and 2019, so a 6-year period, it explained how many dollars the DOL's enforcement has resulted in recovery of back wages to affected workers. That number was at $220 million. It also resulted in 60 debarments. I often hear from contractors, does the DOL really debar, or does the DOL really recommend debarment, and does that happen? So these statistics show that it does. One of the most startling statistics there, though, or information, is that what the GAO reported is that when the DOL comes in to do a Service Contract Act investigation, it finds violations 68% of the time. That's a pretty concerning figure, and another sort of signal to think about as the DOL ramps up with new investigators, what steps should be taken to help with SCA compliance. The 2020 report also talked about the myriad enforcement challenges that persisted at the DOL and enforcing the SCA, and some of them are listed there. Howard touched on some of them. There was no tracking of enforcement tools used by the SCA to see if they were effective or if they helped with compliance. There was poor communication, according to the GAO, between the DOL and contracting agencies, and this resulted in contracting agencies not knowing that some of its contractors were being investigated. And then there was a lack of information provided to contracting agencies about debarment. So people who were debarred were actually getting contracts, according to the GAO. May we please have the next slide? So what the GAO rather did was provide a number of recommendations to the DOL, which the DOL said it would largely implement. And so in May of 2022, the GAO provided a report on the progress that the DOL is making. And here are the 3 key areas where the DOL has made significant progress, according to the GAO. It has developed that tracking system that Howard spoke about that talks about enforcement outcomes. The next step, according to the DOL, is to work on ways to analyze that data so that it can be used more effectively to help with its enforcement. It's also created unique identifiers created in connection with debarment recommendations. So there's a number assigned to a contractor who has been recommended for debarment. So that number follows you, and contracting agencies can see it. It's supposed to be visible in SAM so that there's greater continuity and an understanding of who's been debarred. And then the DOL has provided guidance to DOL investigators for keeping contracting agencies abreast of SCA investigations. And anecdotally, I'm seeing that in investigations, more communications from contracting agencies. So what does this mean for contractors? Contractors should again be prepared for the increased likelihood of an SCA investigation by the DOL, be prepared to defend and get ahead of communications with the contracting agency so that it can explain, or contractors can explain their position, as not all SCA violations are created equal. And again, we've seen evidence of the DOL communicating with contracting agencies and it actually impacting the bid and solicitation process. Could we have the next slide, please? So some other really briefly important takeaways from the GAO report. Again, really good information. I sometimes am asked when contractors are involved in a DOL investigation, how did this happen? Did someone report it? And the answer is the DOL doesn't typically tell us, but the GAO stated here that for that same 6-year time period, it found that 59% of investigations were instituted or initiated because of complaints. The others were DOL initiated. What that tells us is that there's an opportunity on the compliance side for contractors to set up good internal procedures for individuals to make complaints and to address issues about concerns related to wages to hopefully avoid some of that. The other thing that the GAO report did was tell us which agencies had the most SCA investigations, and we see that list there. I won't read them to you, but what was interesting about the report is that the DoD and the Department of Defense and the United States Postal Service comprise more than 50% of SCA investigations. That doesn't mean you won't get one, but it just means that if you are doing business with either one of those agencies, you have an increased likelihood of an investigation according to the GAO. May we have the next slide, please? The other thing that was really interesting was the information provided by the GAO about the sectors with the greatest number of investigations. And you see them there. And they included things like call centers, cleaning services contracts, janitorial services contracts. And then interestingly, I'm looking there at the last one, professional, scientific, and technical services. And one of the things, again, that we're seeing anecdotally is SCA violations for misclassification of people who are like in engineering services, right? Thinking that those employees are exempt when the DOL takes the position that they're non-exempt. The last thing there that I wanted to flag for everyone is the nature of the violations that the GAO report reported on. So when the DOL found violations, 69% of them involved prevailing wage violations, meaning not paying the right wages. Typically, what we see is it's a mapping issue, not that you're not paying any wages, but you're paying it not at the right level. The DOL disagrees with the mapping determination. And then fringe benefits is it's a big one, right? Because individuals think, well, we have, or contractors think, well, we have, a really generous fill in the blank fringe benefit policy, so we're probably in the compliance. But the DOL has gotten in the weeds on fringe benefits and whether or not they're compliant. So time well spent would be looking at your fringe benefits and whether or not they comply with the Service Contract Act. And just to round out here, maybe we have the next slide. The one thing we wanted to touch on is the recent activity that we've seen at the agency level, with agencies taking the initiative to issue proposed labor and employment type rules. So not government-wide rules, but agency-specific rules where the agency has taken the lead. And one such place where we've seen this is with the United States Department of Agriculture. It has proposed its own blacklisting rule. The proposed rule was issued on February 17th of 2022. It is a final rule that is still pending. We can tell you that it's very controversial. Lots of organizations chimed in and asked for an extension of time to provide comments on that proposed rule. It's unclear whether it will move ahead, but it is at least not dead to our knowledge as we sit here today. Under that rule, contractors would have to certify their compliance with a number of labor and employment laws and rules on behalf of itself, its subcontractors, and its suppliers. And Contractors can be subject to False Claims Act liability if their certification isn't accurate, according to this proposed rule. And then for contractors who are bidding on covered contracts, they would have to disclose how they've done with respect to certain labor violations and certify that they have complied with any prior corrective actions that were issued to them, and then have to provide the agency with regular updates on those actions. This may sound very familiar to many of you out there. It is very similar to the Fair Pay and Safe Workplaces executive order that was again issued by the Obama administration, but enjoined on the eve of its implementation, and then ultimately rescinded again by the Trump administration. So time will tell whether or not we see this USDA rule become final, and frankly, whether or not we see a similar rule that is government-wide. Maybe we have the next slide. And then finally, the Federal Trade Commission. I don't know if many of you paid attention to this yet, but just a couple days ago, the FTC proposed a rule that would ban, not just for government contractors, but for all employers, non-competition agreements. And it would ban, again, all non-compete terms and employment agreements with virtually all workers, worker being defined very broadly to include, for example, independent contractors. What's really astounding about the proposed rule is that it wouldn't just be prospective, but prospective. It would require employers to rescind existing non-compete agreements. So that's unprecedented in many ways. Can we go to the next slide, please? This proposed rule would also adopt a functional test for determining whether an agreement is a non-compete. So in other words, just because you call it something else, according to this proposed rule, doesn't mean that it wouldn't be considered a functional test. For example, the proposed rule anticipates that some non-disclosure agreements could be so broad that they would effectively be a non-competition agreement. It's unclear whether non-solicitation agreements would stand under this rule. And then it would only allow for, under the proposed rule as it exists, use of non-competes in connection with the sale of a business. What I will say as I close here is that this is very similar. This particular rule is very similar to some of the state law and local law efforts that we've seen in places like California and the District of Columbia, frankly, to severely limit the use of non-compete agreements. But what we will say is we are expecting a lot of legal challenge, and time will tell. But there are many commentators who would say they would be surprised if this rule gets implemented in its current form. But again, we shall see. Thank you.
Okay, good afternoon, folks. I guess I get the back cleanup here, this august panel. And while you've heard everybody else talk about primarily service contracts, I get the distinct honor to talk about construction contracts. And before I launch into that, I'm going to be talking about three topics. But before I get to that, a little background on the history about why we're seeing so many changes involving construction contracts currently in the labor employment world. Secretary of Labor Marty Walsh, before he was in politics, was the head of the Massachusetts Building and Construction Trades Council. He's now Secretary of Labor. The current Wage and Hour Division Administrator, Jessica Lumen, was the Executive Director of the Minnesota State Building and Construction Trades Council. So, kind of a surprise that we're seeing a lot of activity in the construction world. So I'm going to be talking about three different but somewhat related topics today: project labor agreements, Davis-Bacon Act regulatory changes, and the brand new Inflation Reduction Act prevailing wage requirements. So let's go to the next slide. So what are project labor agreements? For those who regularly work in the construction world, you know already, but for those who may not, project labor agreements are a form of pre-hire collective bargaining agreement that require construction firms competing for public contracts to pay wages, benefits, and comply with other terms and conditions imposed by the local union's private CBAs or collective bargaining agreements. In other words, you got to sign on to the local collective bargaining agreement in order to work on the federal contract. These are all very specific, project-specific agreements for building, say, a federal courthouse or a military barracks or whatever the project may be, but it's going to be project by project specific. In exchange, unions agree to no strikes, lockouts, or other job disruptions. So there are some arguable benefits for both sides. Next slide, please. Now, the history of project labor agreements in federal procurement is a little checkered. Currently, I'm going to be talking about Executive 14063, which was issued by President Biden on February 4th of 2022. But there's been a sort of back and forth volleyball sort of approach about how various administrations have handled project labor agreements. George Herbert Walker Bush banned project labor agreements. President Clinton rescinded that executive order and then permitted project labor agreements. George W. Bush rescinded that executive order and was neutral on the position. The Obama administration created the current regulatory scheme under the FAR. Surprisingly, the Trump administration broke this ping pong trend by not revoking the Obama era executive order and related FAR clause. You can propose your own theories as to why President Trump may not have done that. But then President Biden last year issued the new executive order, pretty much making the PLAs mandatory. So next slide, please. So as I said, there's currently FAR clauses in place. They're listed there on the screen. But the current executive order and the current FAR clauses permit, but do not require the use of project labor agreements on construction projects costing more than $25 million. Next slide, please. But the new executive order changes that and creates a presumption that project labor agreements will apply to all federal construction contracts valued at more than $35 million, subject to narrow exceptions, which I'll get to in a little bit. And also, the executive order also creates a preference for project labor agreements for contracts valued at less than $35 million and any form of financial assistance, grants, subsidies, et cetera, et cetera. It raises sort of the philosophical question as to why the Biden administration feels the need for a presumption for project labor agreements when presumably the purpose of it is to provide wages and fringes to employees, but on federal construction projects, those employees are already subject to Davis-Bacon Act wages and fringes. So it's unclear what the benefit to employees is, other than perhaps getting the guarantees against strikes, lockouts, and job disruptions. So next slide, please. And again, this is what the executive order calls for, that all PLAs must bind all contractors and subcontractors on the project and contain guarantees against strikes, lockouts, et cetera, and also establish a mutually binding dispute resolution procedure. Again, these buy some labor peace at the expense of forcing all of the construction contractors and subcontractors to sign on to a collective bargaining agreement for that project. Next slide, please. Now, I said the PLA mandatory nature is subject to certain exemptions and exceptions. The executive order calls out what those exceptions are, and basically there are three of them. I can read them off, but basically there are three very narrow exceptions, but only after the senior official within the agency makes a written determination and explanation as to why one of those three exemptions applies. So a lot of hoops to establish an exemption. But why would they do it this way? Let's go to the next slide and find out. Section 6 of the executive order requires agencies to publish on a centralized public website data showing the use of project labor agreements on large-scale construction projects, meaning projects more than $35 million, as well as descriptions of the exceptions granted under Section 5 of this order. So in other words, this publicly available website is going to list all of the federal contracts that where project labor agreements are required. And also, this is where senior agency officials are going to have to list their description and explanation as to why they granted exceptions to PLAs. Now, there's no federal contracting purpose identified in the executive order as to why this is appropriate. I have being a former union lawyer, I have my suspicions this is probably to help out unions with organizing, to identify potential targets of a union campaign. That's just my own informed opinion. So let's go to the next slide. All right. So the executive order said that it was effective immediately. and directed the FAR Council to propose regulations, which it did belatedly on August 19th of 2022. And the proposed FAR clauses largely adopt the existing Obama administration FAR clauses, adds a couple definitions here or there, and makes it mandatory, consistent with the executive order, as opposed to merely being permissive. And as of last week, when I checked on this in preparation for this presentation, the FAR Council has indicated that a report is due next week concerning the status of the FAR final rule. So stay tuned. Today's discussion is a little premature, but I'm sure in the next week or so we will have final rules and we can revisit all this. Next slide, please. My last piece on this topic. All right. So the important piece from the proposed rule that was published by the FAR Council is the flow down clause, because everything else sort of tracks what we saw on the existing Obama administration FAR clauses, but specifically C2, where it says the contractor shall not require subcontractors to enter into project labor agreement with any particular labor organization when the project labor agreement includes multiple signatory labor organizations representing the same trade. In other words, the prime can't dictate which union the subcontractor signs on with. Again, I don't know, no explanation to provide for that, but that's what the FAR Council has determined is appropriate. All right, so that's the project labor agreements. Let's talk about Davis-Bacon Act changes. Next slide, please. This is the heart. Thank you. This is the heart of the construction prevailing wage. And again, for those who may not be as familiar, we heard a lot of talk from my colleagues on here about service contract. Davis-Bacon is more or less the same thing, but for the construction industry. It establishes prevailing wages and fringes for all laborers and mechanics working on federal construction contracts valued at more than $2,000. Yes, you read that right, $2,000. All right, and then there are a series of required FAR clauses or Department of Labor clauses and flow downs. And of course, there are a variety of penalties for noncompliance, including contract termination, reprocurement costs, and debarment. That's sort of old hat. But next slide, please. So I'll give you a little bit of history about the regulatory changes. The Davis-Bacon Act was first enacted in 1931. It's almost a 100-year-old statute, hence the $2,000 threshold. Back then, I guess $2,000 was a lot of money for a federal construction project. The last significant Department of Labor refresh of the DBA regulations was back in 1981 and 1982. So it's been a good 40 plus years since they've looked at this in a meaningful manner. And Department of Labor issued a notice of proposed rulemaking in March of 2022. There's a citation there for you. And according to the regulatory agenda, a final rule is expected in 12/00/2022. So we're sort of waiting right now to see what a final rule may look like, but it's not there yet. But you can be sure that it's coming. I'm sure that there were a lot of comments that were submitted, and Department of Labor is looking at it. Because another important note here, typically when there are changes to the Davis-Bacon Act regulations, it's not uncommon to later see changes to the Service Contract Act rules reflecting those Davis-Bacon Act. And so the next couple of slides, I'm going to walk you through some of the issues that labor is flagging in its proposed DBA regulations. And you can think in your own mind, oh my goodness, how is this going to affect Service Contract Act going forward as well? All right, next slide, please. All right, first off, I'm going to kind of go backwards through the proposed regulations. These are all the proposed regulations as issued in March. First, that they flag, the administrative expenses incurred by a contractor or subcontractor in connection with the administration of a fringe benefit plan are not creditable as fringe benefits. There has been a trend in the last several years by Department of Labor to go after third-party administrator costs and other costs associated with administering fringe benefit plans. So this language, there's some language in the background to the proposed rule itself to try to temper it a little bit, but the language as written can certainly be interpreted to severely cut back on the scope and extent of allowable administrative expenses going forward. Next slide, please. Just going to touch upon this one a little bit about fringe credit for apprenticeship program costs. You'll see why when I get to the last part of my presentation as to why this may be important going forward. But basically, it sets up the parameters for what type of apprenticeship program costs can be considered part of fringe credit and which parts cannot. Let's go to the next slide. All right, this is new. The Department of Labor's proposed regulations adds a retaliation provision both under the Davis-Bacon Act rules and also under the parallel CWASA rules, Contract Work Hours Safety Act rules. So what's interesting here is that there is no express statutory basis for this type of language as opposed to other statutes. It's not implied from the Davis-Bacon Act or CWASA either. And it's somewhat analogous to National Labor Relations Act Section 7 rights and protections. But again, there's no statutory basis for this. Department of Labor is just trying to impose it. And again, it's pretty much standard retaliation language that one would typically see enacted by Congress, but gee, Congress didn't enact this. So next slide, please. So following on what my colleague said earlier about retaliation provisions, it's very similar to the non-displacement rule criteria for what it constitutes protected activities for whistleblowing. Again, notifying a contractor when the employee thinks there was a violation, filing a complaint, testifying or cooperating in an investigation, or informing any other person about their DBA or CWASA rights. This is classic whistleblower retaliation, protected activities. But again, there's nothing in the statute creating this. Wage and Hour Division is creating this out of whole cloth. Might there be some challenges afoot for this? We'll see if this winds up being in the final regulations. But let's go to the next slide. So after they create the rights, then the proposed regulations create the remedies. And the administrator may order a contractor to take various forms of remedial action, including traditional reinstatement, back pay, restoration, yada, 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 expungement of warnings, reprimands, and the posting of a notice to workers. Again, sounds awfully familiar as something the NLRA what the NLRB would do under the NLRA. But again, there's no statutory authority for this. So we'll see how this winds up, whether this stays in its current form in the final regulations. But this is certainly a concept that Department of Labor is thinking about and chewing through right now. Let's go to the next page. Okay, debarment. There's a complete proposed revamp of the debarment standards. It used to be that debarment would trigger for aggravated or willful violations of the Davis-Bacon Act. Now it's considered, whenever any contractor or subcontractor is found by the Secretary of Labor to have disregarded their obligations to workers or subcontractors. Disregard is not really defined. It's not clear whether it was any sort of mens rea, like aggravated or willful, or whether it's some lesser standard. And it's also unlike the Service Contract Act, which was discussed earlier, which has a statutory presumption in favor of debarment unless the Secretary of Labor finds extenuating circumstances. So this language is muddying the waters a little bit and is going to, if the language stays as is in the final rule, could present some very interesting enforcement issues and some interesting case law. Next slide, please. All right, disputes concerning payments of wages. This is largely a pre-existing rule, but they're expanding the proposed coverage to include monetary relief for violations of the anti-retaliation provisions and various other procedural changes concerning disputes with payment of wages, which too long to go into today, but trust me, they'll be planning to talk about if the rule stays in its current form when finally published as final. Next page. All right, suspension or withholding of funds. This is again another proposed total revamp. It used to be that if there was a DBA violation, the withholding can pretty much only be from the same contract and from the same contractor. What Department of Labor is proposing here is to pretty much say, look, under any other, withholding can be done under any federal contract with the same prime contractor, regardless of whether the other contract is awarded by the same agency. meaning they could stretch across the entire federal government and withhold money from any federal contract, and also from contracts held by other entities that may be considered to be the prime contractor, trying to get to an alter ego sort of analysis to pierce the corporate veil and to do some other things to get around what apparently Department of Labor thinks are games. But again, it's a discussion for another time, if and when that proposed rule actually goes into effect as written. Finally, let's go to the last slide on this topic. Okay, there are a slew of new proposed definitions or reworked definitions. I listed a bunch here in this slide. You can sort of take these home, think about them, marinate it, but I want to point out two specifically for you for today. First off, the public building or public work definition is proposed to be completely revamped, and largely as a response to the city center case, for those who are familiar with it, where there was construction on District of Columbia leased land, private construction on District of Columbia leased land, and Department of Labor came in and said, gee, the Davis-Bacon Act applies. DC Circuit struck that down and said, don't be ridiculous. This is private construction. There's no public purpose. It's not public work. The proposed definition tries to create rules to get around that ruling. And then finally, the last one on the list, a development statute. In the prior version of the rules were expressly focused on about 3 or 4 different statutes, the Davis-Bacon Act and 2 or 3 other related statutes. Now, I want to read this to get this right for you all. A development statute is defined to mean a statute that requires payment of prevailing wages under the Davis-Bacon labor standards to all laborers and mechanics employed in the development of a project. Now, there's no standards there in that definition as to how Department of Labor is going to decide what is a development statute. And it's basically left to Department of Labor to decide that on a situation by situation basis. And with that, that's a perfect transition to my last topic. Next slide, please. All right. So, Inflation Reduction Act of 2022. So the overarching question you have to think about when I discuss this statute in the few minutes I have left is, to what extent may Department of Labor later determine that this is a development statute that will be subject to Davis-Bacon Act rules? Next slide, please. So the Inflation Reduction Act is a tax law. It provides a series of tax credits and incentives for producing and distributing clean energy. And the tax credits and incentives are significantly increased if the owner developer complies with specific prevailing wage and apprenticeship laws. And so loss of tax credits is even greater if non-compliance with prevailing wage and apprenticeship requirements. Let's go to the next page, please. And so this is a listing of all the various tax credits and incentives. You can all look at that in your spare time. I just want to give you a sense as to how valuable these tax credits are. They're all linked to the owner developer complying with prevailing wage and or apprenticeship requirements. Next slide, please. Okay. There are various iterations of this language throughout the Inflation Reduction Act, but they all pretty much say the same thing. They all say that the contractor and any subcontractor has to comply with prevailing wages as most recently determined by the Secretary of Labor in accordance with the Davis-Bacon Act. But it doesn't say that the Davis-Bacon Act expressly applies. It just says you have to apply the wage determinations. So is this a development statute? Could be. We'll see. Let's go to the next page. So because this is a tax credit statute administered by the Department of Treasury and not a government contracting statute, there are sort of different ways that they're trying to enforce it and to try to create penalties and enforcement schemes by Congress's statute. So if a developer or a contractor or subcontractor fails to pay prevailing wages, it can be corrected by making all the workers whole for any unpaid prevailing wages, paying workers 6% interest, and paying a penalty at a rate of $5,000 times the number of workers underpaid. So it gets pretty significant if we're talking about a large project. Next page, please. Now, while only the taxpayer, usually the owner or developer, gets the tax credit or incentive, the prevailing wage requirement applies to the taxpayer as well as the contractor and all the subcontractors. So it creates a sort of perverse enforcement or compliance scheme for the taxpayer, especially since your small scale subcontractor could not possibly reimburse the taxpayer for the lost tax credits for the subcontractor's non-compliance with prevailing wages. There has to be some very good contract drafting between the owner and flowing it down to all levels of subcontractors to ensure that there is proper compliance all the way. Otherwise, the owner may lose all those very valuable tax credits. Next slide, please. So again, as I said before, there's no overt inclusion of the Davis-Bacon Act requirements, and there's no guidance in the Inflation Reduction Act as to how taxpayers are supposed to enforce the prevailing wage requirements. And because again, this is a tax law, there's no express or implied delegation of any enforcement or regulatory authority to the Department of Labor. However, next slide, please. That, of course, doesn't stop the Department of Labor from issuing guidance anyways. And so you can go find this page online. Department of Labor has a very extensive page about the do's and don'ts from its point of view as to how the prevailing wage requirements of the Inflation Reduction Act are supposed to play out. Surprisingly, or not surprisingly as the case may be, the guidance here looks surprisingly similar to Davis-Bacon Act guidance, although it doesn't expressly cite the Davis-Bacon Act regulations. And it's unclear whether DOL's guidance here has any binding effect because Treasury and not Department of Labor has the express statutory authority for enforcing compliance here. But probably the safest course of action for now, until Treasury and Labor start speaking from the same hymnal, is to assume that Department of Labor's guidance is probably going to be baked into Treasury regulations. Speaking of which, let's go to the next page. Okay. Treasury has tried to issue some guidance on this, specifically about 2 months ago in IRS Notice 2022-61. But for anybody who's familiar with prevailing wage law, the guidance is almost useless. It talks about record keeping in the abstract. It says you have to pick a wage determination from SAM, but doesn't say which ones. It gives some basic discussion about conformances, but doesn't explain that either. But it does incorporate and adopt certain Davis-Bacon Act definitions from DOL's regulations. So next slide. So this slide I want you all to go home, take a look at, think about, because there are a lot of issues, unanswered questions that arise from this statute. As I said, is this a development statute? Is Department of Labor going to sneak in its regulations through the back door? Who knows? Again, as I talked about before, what type of flow downs and contractual enforcement mechanisms will the owner taxpayer flow down to all the contractors, subcontractors, so that they can make sure that they keep the tax credits, which are extremely valuable? There's a record keeping requirement implied here. Would certified payrolls satisfy that? They're not required by the statute, but it probably go a long way. And then there are a whole bunch of questions regarding what prevailing rates apply. It's not clear whether, for those who practice, there are typically 4 different classifications of wage determinations for every jurisdiction. There's residential, heavy, civil, and building. Well, it's not clear what certain types of clean energy projects would fall into either heavy, civil, or building. And there's been no guidance provided other than by Department of Labor on its webpage to suggest which wage determinations would apply. And also there are questions about which wage determinations would apply to the whole project and which would apply on an ongoing basis and have to be modified. And then, of course, there are all kinds of questions regarding conformance, because a lot of the trades that are going to be involved in building this clean infrastructure and clean energy, there's really no parallel for this in existing wage determinations. So there's going to be a lot of unanswered questions. All right, in the couple seconds I have left, let's talk real quickly on the next slide on the parallel issue about apprenticeship. Same idea here. It talks about mandating apprenticeship requirements and requires that not less that a certain percentage of the total hours worked have to be performed by apprentices on the project. Next slide, please. And it breaks it up into timeframes. There was a percentage that applied prior to 2023. We're not going to talk about that because what's done is done. But for this year, at least 12.5% of all labor hours have to be by apprentices, And starting in January 1, 2024, for construction beginning on that date going forward, has to be 15% of all labor hours have to be apprenticeship. Next page. And the triggers in here are very, very light triggers. Basically, any contractor employs 4 or more individuals to perform work has to employ 1 or more qualified apprentices. And the employers have to register apprenticeship programs that themselves are then registered with the Department of Labor or applicable state apprenticeship agencies. And they have to comply with apprentice to journeyman journey worker ratios set by registered apprenticeship programs. Next page. Again, Treasury is enforcing the statute. And same idea, Treasury issued a very nebulous guidance about how the apprenticeship program should work. So Treasury is doing this, but if you see on the next page, that of course has not stopped Department of Labor from issuing its own guidance about how the apprenticeship standards should apply here. So let's go to my last slide. And again, it's the same type of issues we saw with the prevailing wage. There are all kinds of issues about finding the right apprenticeship programs, what effect on wages there will be for insufficient journey workers on site. Obviously there are prevailing wage and fringe issues for apprentices under the Davis-Bacon Act regulations to begin with. Typically, you can pay apprentices a percentage of the wage and usually full fringe, unless the apprenticeship agreement provides otherwise. There is a good faith effort to comply with registered program requirements in the Inflation Reduction Act. But there may or may not be an apprenticeship program for a specific geographic area or for a specific trade, and that's going to have to all be fleshed out. And then finally, there is a correct, as we discussed earlier, for non-compliance with apprenticeship rules, the owner, taxpayer, or contractor can pay a penalty to correct it. To either pay $50 times the total labor hours spent on the project, or to the extent that the Treasury finds that the non-compliance was intentional disregard of apprenticeship requirements, then it gets bumped up to $500 per total, multiplied by the total labor hours. So again, remember, this is a tax statute, but for those practitioners on this call who are familiar with prevailing wages, clients are going to be coming to you in the first instance because, unlike tax lawyers, you understand what prevailing wages are, how they're supposed to work, and having a tax lawyer interpret prevailing wages is sort of like going to a podiatrist to seek dental treatment. They both went to med school, but they're working on different parts of the body. So with that happy aphorism, I will conclude and turn it over.
Michael, thank you. And what a great panel. Look, Service Contract Act, 1965, 58 years old, DBA, 1931, 92 years old, and we still found 2 hours to talk about things and not have answers to questions. I say repeatedly, but not to everybody yet. These are among the most complicated laws that government contractors have to worry about. And listen how few times we mention the federal acquisition regulation throughout all of this. My big thanks to Nicole and Howard, Trina joining us for the first time, and Mike Schreier, a repeat offender. Thank you very much for returning with us and participating. We couldn't have done this program without them. And let me again thank our event sponsors for their support. They're on these next 2 slides. We couldn't have been able to put on a program such as this without their strong support. I look forward to seeing all of you tomorrow, and have a great rest of the day. Thanks.